Thank you. The chair now recognizes for 5 minutes the gentleman from Virginia.
Thank you, Mr. Chairman. I thank our witnesses for their testimony. Ms. Cohn, you mentioned use cogents and indicated there's no statute of limitations for prosecution.
Correct.
Is there anywhere in the United States Criminal Code where we can find a basis for prosecution of that concept generally?
Yes, several Supreme Court decisions have referred to use cogents and customary international law, and it is part of U.S. law just the same way as treaties are once we ratify them.
Thank you. We've all agreed that torture is illegal. Is there any basis for retroactive immunity if you get good life-saving information?
No, there's no justification for torture under the Geneva Conventions, under the Torture Convention, and under the International Covenant on Civil and Political Rights, all three of which are treaties the United States has ratified and therefore part of U.S. law under the Supremacy Clause of the Constitution.
And the fact that you got good information does not retroactively immunize you for the torture?
No, it doesn't. No exceptional circumstances whatsoever will ever allow torture under those three treaties.
And one of the problems with this is that you don't even know if you're going to get good information when you decide to torture. That you start torturing and you may or may not, you may find it didn't work, or you may find the person didn't even have information. How many people, I mean, if we were to allow torture in the cases where you can get good information, how would you know that you are going to get good information when you decide to torture?
There's no way of knowing, Mr. Scott. That's the problem.
Mr. Sands, you've talked about this generally. Could you just specifically say the effect of allowing torture, what effect that would have on United States troops?
Well, firstly, I think that there's considerable evidence that the use of abusive interrogation techniques has undermined morale. I have even in the past few days, from the publication of the article in Vanity Fair and the book coming out, received rather amazing emails from military, very upper echelon individuals who are, shall we say, feeling very positive about the way in which steps are going to draw a line under this historical moment. But more significantly, I think one need only reverse the situation. If President Bush vetoes legislation that this House has passed and that the Senate has passed, which outlaws these techniques of interrogation, because he wants to leave them open to possible use in the future, imagine what that does to someone who is holding American troops or American nationals and also wishes to use the same techniques. It simply creates a basis for exposing American nationals or American troops to abusive techniques of interrogation that are not permitted. And so it creates, I think, an additional risk for American troops in the field and for American nationals, business community, NGOs, individuals traveling around the world doing their honest business. And that is the fundamental problem with what has happened. It has created a fundamental risk for the good men and women of the United States, in particular in the military. And that's what makes this so pernicious.
Thank you. Ms. Cohn, does anybody outside of this administration think that waterboarding is not torture?
This administration, well, at Michael Mukasey's confirmation hearing to be Attorney General, retired Navy Rear Admiral John Hudson testified that aside from the rack and thumb screws, waterboarding is perhaps the most iconic form of torture, going back to the Spanish Inquisition. The United States pushed for and got prosecutions of Japanese leaders after World War II for waterboarding. It's called the water torture, the water cure. There is really no good argument that, in fact, waterboarding is not torture, and that's why I was so puzzled that Michael Mukasey refused to say that waterboarding was torture. I think the reason for that was twofold. First of all, he would have been calling his bosses war criminals because they admitted engaging in waterboarding, and if waterboarding is torture and torture is a war crime, they could be liable under the War Crimes Act. And secondly, under the Military Commissions Act, evidence obtained by torture is inadmissible, but evidence obtained by coercion is admissible if it took place before December 30th, 2005. And so Michael Mukasey knew that that information presumably was obtained by waterboarding, and if that was torture, then that could not be used in some of these military commissions trials. Those are the only two reasons I can think of that Michael Mukasey would refuse to say what everyone else knows, and that is that waterboarding is torture.
Well, can this administration change the law by memo?
Can they change the law? It's either torture or it's not torture, and waterboarding, if you were almost drowning, and some people actually do drown, and so then we're talking about homicide, we're talking about murder. I mean, there's torture leading to murder. But if you are pouring water down someone's nose and mouth until they almost drown, there are just no two explanations for that. There is no good argument that that's not torture. And so if the U.S. passed a law saying waterboarding is not torture, it would be like saying the sun doesn't rise in the east and set in the west. It just would not make sense.
Thank you.
Thank the gentleman.